morning. Hi, everybody. This is Eric Daly with Miller Johnson. Today, we are going to kick off a conversation that will be ongoing into the new year, 2024, about the Corporate Transparency Act and what that means for businesses, entities, trusts and estates, and a variety of other industries, real estate among them, and what you can start to do now to prepare, what you can expect from the team here at Miller Johnson going forward. I'm joined by my partner Raj Malviya today, who spent a lot of time over the last year or so within the trust and estates community in particular, part of the Bar Association nationally, also here in Michigan, tracking the developments. So, Raj, I'm going to kick things off, if it's okay with you, by just asking, okay, how and why did you start to follow the CTA? It's for people who are joining us early. It's sort of an obscure area, but one that's going to be more relevant to people. So, how did it kind of get on your radar, and what have you been up to?
Yeah, thanks, Eric. Hi, everybody. Raj Malviya. Probably for the past 2 years, I've been tracking the CTA, and it really was not by choice. In the trust and estates practice and the tax practice, we create entities all the time, hold different assets to maybe separate risks. We also are heavily involved in trust planning, where we have living trusts or irrevocable trusts, and it's not uncommon for those trusts to own interest in entities or receive gifts or transfers in those entities, or business owners, right? Business owners who have basic estate plans set up might have interest in their ownership in a revocable living trust. So part and parcel of my involvement has just been by necessity. Our practice area has to understand the CTA because we are consistently interacting with entities. I'm also very involved at the national level with the American College of Trust and Estate Council and the American Bar Association, and we have formed committees over the past few years to study this area, its developments, and really track what's going on with the federal government. This is the Treasury Department and the arm of Treasury that's administering the Corporate Transparency Act, is the financial crimes enforcement agency. They're known as FinCEN. So we're going to reference FinCEN a little bit today. But I have a different lens than Eric. I think it'll be interesting to hear Eric's take on how he sees the CTA and how it's impacting the M&A and corporate practice. But our themed approach here is it needs to be a part of many different practice areas, and we all have to sort of work together and help each other understand what's involved, how it applies, and what we can do to prepare. So that's the theme of our webinar today. Eric, how about you? What's your lens on the CTA?
Yeah, so thanks, Raj. Exactly right. I'm an M&A and corporate law attorney, so we are regularly forming new entities and helping clients with existing entities, ownership structures. And so the CTA, Corporate Transparency Act, will have a significant impact on many of the existing companies that we work with, but also anytime we're forming a new company for a transaction or for another business purpose with our clients, we're going to need to ask some new questions now that we have the Corporate Transparency Act coming into effect, to make sure our clients are positioned to report and keep a good compliance record if they are subject to reporting under the CTA. So with that, I'm going to jump in and just kind of get into the agenda and start to get into the substance of the CTA. And Raj, we're lucky to have you help guide us through that. I won't go through all these bullet points, but really today at the highest level, we are trying to keep it big picture. We're going to have follow-up webinars on some of the more specific issues that can come up under the CTA for various exemptions or questions about the reporting logistics process with FinCEN. For today, we want people to walk away knowing what the timeframes are, have some sense of what questions they should be asking themselves, and what some of the key dates that are out there. So that's the main theme today. And with that, I'm going to keep things going and just ask Raj to kind of tell us what is
Yeah.
the CTA. We've mentioned it many times already, but what exactly are we dealing with?
Yeah, thanks. Thanks, Eric. And for those of you who caught some of our, our pregame back and forth, Eric and I struggle sometimes when we give these presentations, how long we should apply the duration. We've spoken with a lot of attorney groups, accountant groups, wealth management groups. I mean, this webinar, we've really opened it up to everybody, and we do that for a reason. We just think it's good for the community, the professional community, the client community, advisor community, anyone who really is interested in learning about the CTA to join these. This is not for our clients. This is for everyone. So spread the word. As I mentioned before, the more we can educate each other and be helpful, that's what we need to do. And so Eric and I agreed. I think we just want to have a half an hour of discussion. Let's take you through this PowerPoint as an outline. This PowerPoint, I think, has exactly what you need to know in terms of takeaways for an introduction. If you want more material, you want more detail, you want citations, you want analysis, there's some other resources available. If you reach out, there's also there's plenty of information on the web already, and there's some links that are in our alert that we publish to FinCEN and to Treasury. So we invite you to take a deeper dive after you get this, I think, initial broad brush approach. So the CTA is the acronym for the Corporate Transparency Act. The bottom line, everyone, is it's here, and it's a big deal. It's been in effect, I should say, through legislation for 2 years, but the effective date is going to be Jan 1 of 2024. And the CTA is, I look at it as a regime to combat money laundering, terrorist financing, illegal financial activity, those types of crimes. And I think it's our government's way of trying to get the United States on an equal playing field, or at least trying to get the U.S. on an equal playing field with a lot of the other foreign developed countries who already have similar legislation in place and have had legislation in place like this for quite some time. And the reason it's a big deal is because I think the regime, if you look at the rules and what we're going to go through today, it casts a very large net, and the mesh of that net is very fine. So it really is capturing a lot of entities, large, small, medium, but private entities with some exceptions. And these are the types of entities we interact with on a daily basis. So we're gonna dig in a little bit on how the CTA regime is going to unfold, but 30 million entities, right? That's the statistic we're seeing, is it's going to impact, beginning Jan 1, 24, 30 plus million entities. So it is going to, again, that net is very large, the mesh is very fine. Don't get tripped up on the title of the legislation. The word corporate is a misnomer. It's going to apply to a defined term called reporting companies. So it's not just corporations, it's not the corporate form. It's going to apply to many different types of entities that we'll see in a moment. We'll flesh out that definition. And the entity needs to be defined as a reporting company. And the purpose of the CTA is to really force a reporting regime that's going to require these reporting companies to list all of its owners. And as we'll see in a moment, owners is a very broad term. An an owner needs to be an individual ultimately, but that owner is going to have a certain threshold of ownership interest or control. And the definitions, again, are they're quite broad, they're nuanced, they're complex, and that's part of where I think professionals come in, is to help reporting companies really understand who its beneficial owners are. And one more point I'll make on this slide, Eric, and then maybe kick it to you with a couple comments, is, again, that we're going to see that the CTA is going to apply to a lot of private, small or medium-sized entities. The large, highly regulated entities, they already have rules and regimes that apply to them. They're not going to be impacted by the CTA because they might be impacted already by the SEC or banking regulations or other types of rules. So the CTA is really an effort to capture those entities that are maybe flying under the radar. So, Eric, any follow-up on this slide, and maybe kick us off on the next slide?
No, I think, Raj, I agree with you. It's this sort of sweet spot, if you will, of it's not so sweet. Maybe it's a bitter spot of being in this category of companies that's not in the exceptions from CTA reporting, which there are 23 categories of exceptions. We won't go through all those today. Some of them may or may not apply. So you're large enough that the CTA is on your radar, and you have some compliance obligation, but not so large that you fall into one of the exemptions. But in the first instance, I just want to emphasize that pretty much any entity formed in the United States, unless it meets one of those exemptions, should consider that it either is or will become subject to the CTA at some point. And so there's some level of advanced planning that can go into putting organizational documents in place so that if and when the time comes that you do need to get that information from your beneficial owners, you have a way to do that. But we'll come back to that. And for now, maybe just provide a little bit more detail about some of the upcoming key dates, which you already alluded to. But my main takeaway here, Raj, before the details, is just that there's a lot of alarms going off here at the end of the year about the CTA, and it's good that it's coming onto people's radars more and more. But it's not the case that people need to make filings on January 1st of 2024. Like, we've got a little time here still to plan and to get ready for this, and we still will after the new year. Not a great idea to wait till the last minute, but we also don't want people to overreact, I guess, to this news. It's the kind of thing that there's still plenty of time to reach out to your advisors and kind of get the house in order to be CTA ready.
Right on. Yeah, maybe we go to the next slide just to dig in a little bit. So, you saw from that previous slide, this is all going to be handled electronically by FinCEN, and there'll be the system dubbed the BOSS system. For those of you who are 80s television shows like me, you remember the show Who's the Boss with I think Tony Danza, and we're going to see who's the boss here as we approach January 1. This new system, the beneficial owner system, is going to be the most important online platform, I think, for entities wanting to comply. Reporting companies are going to need to get familiar with it through their advisors or directly. There are going to be some different platforms that will assist with complying and uploading to the BOSS system. So we'll talk a little bit about that towards the end. But let's just cut through these definitions. We need to understand that the CTA is looking to find owners of these reporting companies. So the CTA is forcing a reporting company to look under the hood and identify its owners. And the information that will ultimately need to be submitted, there's a laundry list here on this slide, but the basics: the name, date of birth, address, business address, for those who are involved in creating the entity. There's an opportunity to get a unique identifying number. And I think what's going to take a little time to get used to is an image. So there needs to be an image uploaded of the beneficial owner, the individual, right? So that's going to be a driver's license, a passport, something along those lines. The reporting company is also going to have to list some general information on this online submission. The name of the entity, including DBA's address, right? What jurisdiction of formation is this? A Michigan entity, a Delaware entity, and again, an identifying number. So tax ID number, EIN, something similar that it uses for reporting. So maybe we go to the next slide.
Just to pause on this though, Raj, and then
Yeah,
we'll go to
sure.
the next slide. I apologize if this is self-evident, but the degree of change here is so significant compared to what we have had historically in the US, where we don't have federal corporate law. We still won't after the CTA takes effect, but this is all traditionally, to the extent it has ever happened, which is minimal, in the terms of beneficial owner disclosure. It's all been at the state level, through secretaries of state's offices, clerks, maybe, in some states. But the level of detail here now is an entirely new federal requirement, which goes beyond, as far as I know, what any state has required in terms of beneficial owner disclosure. So even if you were in the state that required more disclosure than other states, you're likely to have new reporting requirements unless you have an exemption from the CTA, for your beneficial owners and control people, even if you're a relative small business, for example. So I just don't think that can be overstated, the magnitude of the change here for businesses that really have not had federal government, other than their tax returns, perhaps, federal government reporting or filing obligations in the past.
So
Which is,
Eric, I mean, who is impacted by the CTA?
so basically, we'll get to the exemptions, but it's really, again, in the first instance, I think you have to assume any business in the first instance, let's assume that it's going to be impacted by the CTA, even if it's the mom and pop, or maybe especially if it's a mom and pop business, restaurant or retail store, whatever it might be in your community. Doesn't have to be, a national presence, anything like that. It could just be entirely within the state of Michigan and you're a Michigan company or any other state. Unless you have an exemption, you're going to be subject to, the company will be subject to the CTA, and it will have to disclose its major owners above 25%, but also any directors and officers that are considered to have substantial control over the company, even if they're not owners. And then it will also impact many outside advisors who work with those companies, like Miller Johnson and other law firms, accountants, people who keep track of information for these companies, and will need to be in a position to help provide information, advise on what updating requirements there might be for previously reported information, and so forth. So it's, as you said before, it's a very large net. And the question really hinges on, whether you are a reporting company. So Raj, I'll just kind of go through this real quickly because I've
Sure.
alluded to it already a couple of times. But as you said, it's a reporting company is really, in the first instance, any corporation, LLC, or other similar entity. So, depending on the state, you might have limited partnership, or it could be a professional limited liability company, that sort of thing. If it's created by the filing of a document pursuant to the laws of a state or tribe, then again, you're going to assume that at that point you're looking to see whether you get an exemption, because at that point, okay, you're assuming you're a reporting company. If you're US based, if you're a foreign or non-US, if you're a non-US company, you're formed under the laws of another country, but you're registered to do business by the filing of a document with a Secretary of State or similar office. There again, okay, unless you have an exemption, you're going to be subject to the CTA. So it makes it very important to understand these exemptions. And Raj, I'll kind of let you go through this in a little bit of detail. It's beyond the scope of this initial high level discussion, but maybe some prevailing themes that you see in the exemptions that might be more common for companies who or other entities who are looking to see if they do not have to report under the CTA.
Yeah, thanks, Eric. So, we're taking you through a CT analysis methodically. And once you've identified you have a reporting company, you might qualify under one of the 23 exemptions. But big picture, think about these exemptions as entities that are already heavily regulated, whether they're public charities, they're regulated under the Securities and Exchange Commission, they're large firms that are registered under Sarbanes-Oxley, they're publicly traded, they're large organizations, they have a sizable amount of employees and revenue and tax compliance. These are the types of entities that FinCEN does not care about because they're regulated in other ways. But there might be some close calls. So I think there'll be situations where it's pretty clear you have a publicly traded company. We don't care about the CTA. You have a public accounting firm. You have a financial institution that's already regulated by the SEC and the banking laws. You have a public charity. Fine. We know those are not. We don't concern ourselves. We're not concerned about the CTA, but there might be some close calls or some gray area where you have an entity, maybe a large employer, and you're trying to measure whether that employer meets the large operating company exemption, right? And there's some definitions, some nuanced definitions and terms that apply where you have to have a certain amount of U.S. gross receipts, certain location, certain number of employees, and it's not always going to be clear cut. So I think big picture, no, there are exemptions out there. It might require peeling some more layers off the onion to see if a certain exemption applies. And I think that's where, advisors in your circles who are following the CTA or who are versed in the CTA are going to be helpful. I'll just touch on this quickly, Eric, and then I think we're on track with our timeline. Once you've identified that reporting company and you determine it doesn't qualify for an exemption, assume that there's going to be a filing in the BOSS system. And, as Tony Danza would say, whoa, that might require a lot of work ahead because now we're looking under the hood of the reporting company to see who are the owners of this reporting company, and you're really looking at a defined term called beneficial owner. It's just the rule of three. If it meets one of these three categories, we're going to list that beneficial owner on the submission. So you've got someone that owns at least 25% of an economic interest. You've got someone who controls the ownership or at least, has that 25% voting interest or control interest in the entity. Or this is the kicker. This is a very broad category. Just someone who has substantial control over the company. And that is a really tricky definition under the CTA rules. So it's not always going to be similar to the reporting company analysis. It's not always going to be cut or dry on who the beneficial owners are of the reporting company. Eric, any other thoughts on this slide before we move on?
Yeah, I think the only thing I'll emphasize, Raj, is just that it's an individual, right? So we're not talking about another company. Like in these reports to the government, to FinCEN, you need to identify an actual living, breathing individual and provide the information to them. So it's not enough to just kind of kick the can to another company, unless that other company itself, there might be a few circumstances where you can do that. if the other company's already registered with FinCEN and reporting. But in many cases, you're going to have to look all the way up the chain in these cases to actual living, breathing human individuals.
Right, right.
Okay. So company applicant, Raj, I'm going to go through this super quickly because I don't, for this audience, it may not be as timely, but for newly formed entities in next year, this doesn't apply to entities that will already exist before the end of this year, 2023. But for newly formed companies starting next year, in addition to all the beneficial owner information that needs to get reported and the information about the company itself, the company applicant, which is the person or people, depending, it could be up to 2 people who are involved in directing or actually creating the entity. So it could be paralegal, it could be a corporate formation service, it could be an attorney or an accountant. Their information will also need to be included on the form when it gets reported. So just know that that's the case. You may need to be getting information from some of your advisors if you're forming new entities next year. And I'm going to go on from there, Raj, just for the sake of time. Okay, due dates. This is what we talked about earlier. While the CTA is going into effect starting on January 1st, and for existing companies, that will mean they have a full year, so all of next year, 2024, to get their reports in by January 1st, 2025, if they don't qualify for an exemption. Newly formed companies formed after January 1st for 2024 only, under the existing rules, will have 90 days to get their initial report in if they do not qualify for an exemption. So if you take that out, it means that, you know, around the end of March is when, if you had a new company formed on January 1st, and you get down to around the end of March 2024, that's kind of like the earliest potential deadline under the CTA for when you'd actually have to get information in or be out of compliance with the act. And then on an ongoing basis thereafter, starting in 2025, that 90-day period gets shortened to 30 days. And that 30-day time frame will also apply to any updates to information previously reported. So if you have a new beneficial owner join, you have to make an update kind of in real time, or at least within 30 days. It's not an annual report, for example, that you just update each year. You kind of updated it more or less in real time. And then if you somehow qualify for an exemption later after your initial report, you'd report that within 30 days, and likewise correcting any previous errors. So the timeframes start to get a little bit shorter here for newly formed entities and for updates to existing reports. And then I know there was a question in the chat box about penalties. So there are potential civil and criminal penalties under the CTA for, in particular, for willfully providing inaccurate or incomplete information, or willfully failing to report, complete, or update the information. And actually, just yesterday, the FinCEN released some updated frequently asked questions. One of the questions that, Raj, I know we and you had been following was whether FinCEN would take the view that a beneficial owner who refused to provide information to a reporting company would be considered in non-compliance and subject to these penalties. And at least at this point, FinCEN is taking the position that they would be violating the CTA, even though they're not a reporting company, they're just a beneficial owner, by not providing their information to the company so that the company can meet its reporting obligation, which I don't know if you have any thoughts on it. In some ways that clarity is useful, but I think we may also see some people take a different view as the companies they're investors in are navigating the CTA.
Yeah, I mean, maybe just one point, and I think we can move on. The penalty seems self-explanatory. I would say that FinCEN, it's going to take some time for FinCEN to figure out in practice how this is working, because if you look at the practical challenges of this reporting, if you have a company that wants to report, doesn't want a willful violation, doesn't want penalties or jail time, they want to do this. They want to accept it and move on. But then that reporting company or a representative in that reporting company is having difficulty getting information from one of its owners. That could become a practical issue, and you're butting up against a filing deadline. So we're gonna, I think, hopefully see more guidance on, what is sort of good cause here? What is reasonableness? What does the reporting company have to do in order to try hard enough to get that information? But at some point in time, if an owner says, nope, I'm not going to provide this information for whatever reason, FinCEN does recognize that. And, those same penalties you saw on the prior slide, those will also apply, at least in FinCEN's mind, to those beneficial owners. Eric and I, we're not opining on whether that's right or wrong. We're not opining on policy. We're not opining on, what are the avenues for legal enforcement. I think right now we're just trying to really piece together all of the principles and the guidelines that we're hearing in order to try and make some sense of all this when it's in practice in January 1. Thanks, Eric.
Yeah, and I wouldn't want to be in that position. It's not a great position to be in, right? As a company where you're kind of your investors came in on the basis thinking maybe it was going to be confidential and there wouldn't be disclosure, and now you have to take a different point of view. So when you go out and talk to those investors who might have that perspective, and it could be the opposite, I suppose, too, where an investor believes that CTA does apply and the company doesn't report. So, those are situations where it can be helpful to have advisors come in and help kind of look at the circumstance without a predisposition on the policy one way or another. One thing we talked about the disclosure regime, and I know we're a couple of minutes over here, so this will be quick. I did want to emphasize that this is not a publicly searchable database, at least in theory. Whether the security apparatus supporting the BOSS system is up to the task, I think, is not clear to me anyway. I think it's a bit opaque right now, kind of what level of confidence people should have in the security of this new BOSS system. It's obviously going to be a repository for a ton of sensitive information that would-be cyber criminals would love to get their hands on. So I hope there will be more communication to the stakeholder community subject to the CTA about why they should have confidence in this new BOSS system. But in theory, it should be confined to FinCEN and then other federal agencies involved in national security, intelligence, law enforcement, and at the request of state, local, or potentially even international law enforcement and possibly some financial institutions, there will be other mechanisms for non-national security, non-FinCEN government personnel to gain access to certain certain beneficial ownership information. And there are rules that and penalties that would apply to those people if they abused that access or misused the information that they received, for example. But is again not going to be, in theory, something that is just publicly available for people to peruse without a legitimate law enforcement purpose.
Eric, I can cover this just briefly. How is Miller Johnson involved? Well, we have a lot of stakeholders here, obviously, who are interested in the CTA. We've been following it. We think it's important not only as lawyers to understand it and become versed in it, but we have millions of clients who are going to be impacted by this. So what we're trying to do in this initial phase is do a couple things. Put together and assemble a group of experts from different practice areas, because the CTA is going to impact employers, it's going to impact real estate developers, it's going to impact trust and estates, it's going to impact mergers and acquisitions, it's going to impact employee benefits, right? A lot of different practice areas are going to be impacted. So Miller Johnson has put together a team of attorneys and paralegals to become versed in this area, share ideas, thought leadership, and then really work internally and externally to build the right infrastructure to handle CTA analysis and compliance when we're asked and when we're engaged, and also outreach where we want to try and teach the subject. We want to be helpful. We want to engage with the community because I think a more compliant community is going to be better for everyone, regardless of whether Miller Johnson is the advisor or not. So those are really our main goals. And I think what you see here on the slide is at least what we're already doing for existing clients or those companies that want to reach out to us for help is we're going through this methodically, just as how Eric and I walk through this short outline with you. We first have to determine, do we care? Do we care about the CTA? Do we have a reporting company or not? Does an exemption apply? Looking under the hood of the company, do we have owners? Who are the owners? What if we have multi-tiered structures, entities, trusts that are owners? You typically see that with a lot of larger private clients. What about deadlines? We may not have a straightforward deadline. It depends on when the entity was formed. It also may depend on whether any changes happen within the entity, right? Or if any new information has become known. That's going to set us down a path of different deadlines that apply. And we want to be out in front of it. We don't want to be behind just based on the penalty exposure. I think, part and parcel of handling this type of work, whether it's Miller Johnson or another professional office, is having the ability to do intake, having the right capabilities, software capabilities, security, infrastructure. Those are all things that the task force is looking at right now to make sure that the user experience is met, and internally we're able to process this information and properly handle the work. And then there's a lot of communication, right? I wish it was as simple as sending out an email saying, please send us everything that we need to submit a filing in the BOSS system. It's going to take a little bit more handholding, interfacing with reporting companies, their owners, understanding structures, right? Interfacing and communicating with third parties. So a lot of that should involve a quarterback. So Eric, any other comments on what we're doing here at the firm before maybe we offer some next steps?
My only thematic thing that I would add, Raj, is that again, this is not a one-time report and you're done, right? So, or one-time determination that you are exempt and then you're done. You've got to continually look at this for updates to see if you lose your exemption or you get an exemption. So we are, Miller Johnson, we're trying to take a longer term view of this so that it's not, yes, we want to give peace of mind in the near term that you've met your initial obligation, but also set up a good process and secure system to make sure that as ongoing reports and updates are due, that we can kind of minimize the amount of friction and times you need to go back to people to ask for information, that we have a secure way of setting that up. And that's why we want to dialogue with other advisors and clients, of course, themselves to figure out, what does that look like in the long run? So we'll be having additional webinars and content around those topics, but certainly welcome people who are starting to think through these issues and pain points that they might envision down the road.
Yeah, so yeah, Eric, no, please go ahead. I mean, I know you and I have talked a lot about this, so please go ahead. Yeah,
so
what should we be thinking about?
Yeah, just in wrapping up then, here at the end, and we'll see if there are any remaining questions. We've hit on most of these things already, but if you've received this webinar invite, I presume you're on our email list and we'll get future updates, but you can always subscribe to the Miller Johnson updates and webinar alerts. In the meantime, as we're approaching January 1st, just gathering information if you don't have it handy to have at least your internal house in order, even if you're not yet reaching out to owners or investors to kind of kick off the process externally. But giving them a heads up, hey, this is going to be something that needs to happen next year or may need to happen next year. Wanted to let you know. That way you're not waiting till the last minute to engage with them, or it's not coming as a surprise. This will be appreciated by them. It will make you or your other advisors or clients look better if you're starting the dialogue sooner. And then just knowing who your trusted parties are, kind of within your professional ecosystem to kind of work and collaborate toward compliance on this. And compliance may not mean reporting. It may be that compliance is you conclude you have an exemption based on the information you gather. And so just beginning that investigation sooner than later is a good idea, but also understanding that you have time, some time here into 2024 to complete that, and so to do it thoughtfully before just submitting a report, when you first can. So Raj, that's really what I wanted to cover. Anything else that you'd like to share before we wrap up?
Yeah, thanks, Eric. I mean, just a couple other points are, it's hard to know, this is so new, what advisors are really going to be handling this type of work. And we're starting to see third parties that are offering services on this. Accounting firms might be in the space. I mean, my view is, I do think law firms are probably going to be the primary go-to resource, just because lawyers are involved in forming entities and governance and transferring interests and certain aspects of compliance. And so I just view lawyers sort of as the default to, provide guidance and resource on this. But at the same time, I think at this stage, we're really looking to collaborate with, all advisors across the spectrum, just to really share knowledge and try and be helpful. So, please, as Eric mentioned, try and, engage with your advisor teams, look for the resources that not only Miller Johnson is providing through these webinars and alerts, but really any resource you have on the CTA, because knowledge is power. And the more you know about the CTA and are prepared, I think the better off, you'll be, or your organization will be going forward.
Yeah. And Raj, there was one question in the box, and it's probably beyond the scope of this discussion, but it's a good question. It's, where did this come from, the CTA? Can it be challenged? We very briefly touched on where it came from at the beginning, but very, very briefly. We won't get into a ton of detail, but basically, this is legislation that had been kind of pushed for at least a decade and hadn't gotten through Congress, and finally did get through Congress at the very end of 2020 or early 2021, and actually overrode a presidential veto. So at the time it passed, there was enough congressional support to override a veto, which we don't see frequently. Can it be challenged? I suspect we will see there'll definitely be challenges to it. Whether any of them find any traction in the courts, I don't know. There might be some aspects of the rulemaking by FinCEN and the implementation that come under challenge, given some of the trends we're seeing in sort of challenges to agency rulemaking authority in general and administrative agency action at the federal level and in the Supreme Court. So I'm sure we will see challenges, but Raj, let me know if you disagree. I would not want to be hanging my hat on the idea that any of those challenges will be successful as a legitimate basis for not complying. I think government will still take the view that you are willfully not complying, even if you think, hey, one of these legal challenges is likely to succeed or maybe legit.
Yeah, I know there's a few ongoing lawsuits in federal court, I believe, and one of them might be on behalf of the, small business administration, but challenging, right, the constitutionality of it. But I agree with Eric. I mean, there are no decisions, there are no opinions. We have a statute, it's here, it's passed. It's been blessed. It is the law. It's happening in our discussions with FinCEN, or those, who are interacting with FinCEN. The government is ready to implement this. The BOSS system is ready to go, waiting behind a firewall for release on January 1. So I think the best thing you can do is accept it and prepare for it. But if developments happen over the course of the next year, you react. And I just wouldn't want to be, caught with a non-compliance, because as we've seen, the penalties for willful failures are pretty significant.
Right. Okay. Well, and on the last point, there are the penalties from the government, but then there are also expectations that other third-party institutions may be looking for evidence of CTA compliance, for example, your banking relationships and things like that. So it's going to work its way out now that we're this far along, outside of the federal enforcement system, into just sort of the expectations of being on due diligence questionnaires and all sorts of things like that. So I agree, being prepared, but not rushing into the filing either, as we mentioned before. Taking the benefit of the full time you have while still preparing in the background is sort of what we're working toward here. And so we thank everybody for doing that with us today. Excuse me, today, this sort of initial kickoff of our CTA working group discussion and collaboration, and we will look forward to doing more of these to help answer questions and kind of navigate this as it's implemented together in the coming months and year. So thank you, Raj, and thank you, audience. We appreciate it.
Thanks, everyone.
All right.